The tiny city of Grants Pass, Oregon, now in the national spotlight, the highest court in the land.
There's not been a homelessness case that has gone this far through the legal system, ever.
The Supreme Court of the United States deciding a case with implications stretching far and wide.
Whether they live in Grants Pass or Seattle or Miami or New York, this is a national issue.
The question, can cities punish people for sleeping or camping in public?
I have probably at least $6,000 to $8,000 in fines.
Are those legal consequences cruel and unusual?
Ultimately, our citizenry cannot utilize park spaces.
Where are they supposed to sleep?
And what will the ruling mean here in Portland?
If you have access to reasonable access to a shelter or housing, you may not camp in the city of Portland.
Here's the story. I'm Pat Doris. Welcome to The Story. Tonight we're doing a special show, a deep dive into the upcoming Supreme Court ruling involving homelessness. The High Court is widely expected to uphold a law in Grants Pass that has been challenged as unconstitutional because it fines homeless folks for camping or sleeping in public places. Overturning that law would potentially free cities and counties in 9 states and 2 territories, covering tens of millions of people in the West, to enforce tougher rules against homeless camping on public property. Other parts of the U.S. are not under the same restrictions. Still, the ruling could influence policy across the country for years to come. The decision is expected out tomorrow or maybe the next day, since that's the end of the Supreme Court's term before summer break. We don't have a show tomorrow night because of the presidential debate, but we've been doing a lot of work to give you context on what this ruling is going to mean. So we're giving it all to you early. That way you're going to know a lot more than your neighbors or friends. While we don't know exactly what the ruling will say, everyone we've spoken with on both sides of the argument believe the court will uphold the Grants Pass law. So how did we get here? To answer that question, we have to first go back to 2009 in Boise, Idaho. A homeless shelter there closed, and 6 people were cited for violating a city ordinance that makes it illegal to sleep on public property. That became a federal case. It took nearly 10 years for Martin v. Boise to make its way through the court system, but in 2018, the Ninth Circuit Court, a federal appeals court, ruled with the plaintiffs.
You cannot criminalize the status of being a homeless person who needs a place to sleep.
They said it was a violation of the 8th Amendment, which prohibits cruel and unusual punishment to charge homeless people for sleeping in public if there are not enough shelter beds available for them. The Supreme Court in 2019 declined to take the case and let the Ninth Circuit Court ruling stand. The Ninth Circuit covers 9 states in the western U.S., including Oregon, Washington, California, and Idaho. So the ruling affected all of those states. 2 years later, Oregon passed House Bill 3115, which essentially codified the Martin decision. It says that any local law regulating sitting, lying, sleeping, or keeping warm and dry on public property must be objectively reasonable as to time, place, and manner for people who are homeless. In May this year, Portland City Council passed a camping ban for public property. It bans people from obstructing sidewalks and private property and prohibits camping if shelter is available. It's a watered-down version of the original ban, which was caught up in court.
While I realize there are people who wish that we could act in a stronger manner and in a more forceful manner, it would be in violation of Martin v. Boise, and it would be in violation of House Bill 3115.
Now to Grants Pass, which passed a set of ordinances that would fine people for sleeping on sidewalks, streets, or in parks. A group of homeless people sued the city, and the Ninth Circuit Court ruled in their favor, citing their earlier Martin v. Boise decision. But this time, when the city's attorneys went to the U.S. Supreme Court, the court agreed to take up the case.
I think the court took this case precisely with an eye to reversing the Ninth Circuit's decision.
They heard arguments back in April.
Where do we put them if every city, every village, every town lacks compassion and passes a law identical to this? Where are they supposed to sleep?
We usually think about whether state law, local law already achieves those purposes so that the federal courts aren't micromanaging homeless policy.
And that is how we got here. Now, two other facts for you on this Grants Pass case. It involves 608 homeless folks from the Grants Pass area. And secondly, the Gospel Rescue Mission there has 138 shelter beds, but none of those were counted by the lower courts because, as the court said, they had substantial religious requirements. Now, an obvious question is, if Grants Pass is upheld and Martin v. Boise essentially tossed out, what's that mean on the streets of Portland? Well, we've talked with several folks as we prepared for the ruling, including Portland's Mayor Ted Wheeler. He says it will not have an immediate impact. Mr. Mayor, thanks for making time to be with us today. We're recording this before any announcement has come out on Grants Pass and the Boise v. Martin homeless decision. But assuming that it is overturned, what's that going to mean for the city of Portland and the streets of Portland?
Well, first of all, the main strategy that we're pursuing as an administration is going to continue. And that is, on one hand, we're going to maintain the public right-of-ways and public safety. On the other hand, our constituents overwhelmingly want us to offer humane alternatives to people living on the street. In other words, they want us to help them access whatever services they need to get off and stay off the street. Behavioral health services, addiction treatment services, and the like. That's going to continue. Moreover, it's also important for people to understand from a legal perspective, even though Martin v. Boise may get overturned, and in fact, I think people sort of expect that it will be overturned, the state of Oregon, through the legislature, took the step of codifying Martin v. Boise into state law. So even if Martin v. Boise is overturned, we still have to comply with the state law, which is House Bill 3115, which requires us to have reasonable time, place, and manner restrictions.
Okay, so
that's
first off,
still in effect.
No change. People are not going to look out their window and see a big change in the city of Portland.
Not until the legislature takes up House Bill 3115. If Martin v. Boise falls, then the question for the legislature is, do they then want to revise or get rid of House Bill 3115?
Okay, so despite the federal ruling, Oregon has a state law that says restrictions on homeless camping have to be reasonable for time, place, and manner. So what does that mean? Well, time means the restrictions when those restrictions kick in, for example, from 8 in the morning until 8 at night. Place means where camping is restricted. For example, you can't camp near schools or in doorways or businesses, parks, that sort of thing. And manner means what folks are using to camp. Are they in a sleeping bag or a big tent? How big is the tent? Can they collect stuff outside the tent? All those things. One issue Portland is still trying to figure out: what is reasonable for any of that? Okay, and I'm always confused when I hear this reasonable time, place, manner. What is that?
It is confusing, and I'm glad you said that, because to comply with that state law, the city of Portland passed an ordinance that we thought was very moderate in terms of time, place, and manner restrictions. We believed we'd met what is called the reasonable standard that is required under House Bill 3115, but a Multnomah County judge enjoined us, meaning she decided that we had not met the threshold for reasonable time, place, and manner restrictions. So that basically put it on hold.
Okay, but what does that mean? Reasonable time, place, and manner?
We don't know. Well, and so here's the problem.
Okay, but
the term reasonable hasn't been defined by the legislature, and that is one thing that I would request that they do. If they want to keep some time, place, and manner restrictions in place, they have to define reasonable, because the court refused to do it. We thought we defined reasonable. The court refused, said that we had not done so, but refused to define it for us. And so it goes right back to the legislature. What did you guys mean when you said reasonable? For us, we had a very clear path to what we thought it meant.
So how's that for a little bit confusing? To get some more perspective on the question of House Bill 3115, we talked with Ed Tumpfreak. He's a municipal lawyer for several cities in Oregon. He says 3115 is going to need some work.
Lots of questions will come up. So in terms of 3115 being clear and objective, it's not. It's full of soft, vague language, and it would be very helpful if some state agency, maybe the Attorney General's office, were directed to write some regulations to help clarify what's meant by it. Otherwise, cities will do it, and then it'll be going through the court system, and judges will have to make the decision as to what's allowed and what's not.
But one of the lawmakers who sponsored the bill back in 2021 says she thinks the law has been working for cities. Here's Representative Pam Marsh from Southern Oregon.
Honestly, I think the 3115 has worked pretty well in giving cities direction. The city of Medford, I represent a little part of the city of Medford in my district, passed an ordinance that was challenged in court. What the court said, and it was one of the same judges who ruled against Grants Pass, in the case of Medford, said the city had really met that standard of reasonableness. They looked globally at the programs that are in place and what the ordinance said and validated the ordinance. Ashland has passed a similar ordinance, again, ensuring that the ordinance is paired with services that actually can help people with the multitude of issues that they're struggling with when they're on the street. An ordinance has to be paired with services in order to be effective. So what I've seen in my own district is I think the state law has provided adequate guidance. And I think cities have stepped up to recognize that while they need to address health and safety issues on the street, they also need to be there in a supportive way for people who are struggling.
Now, enforcement of any effort to curtail homeless camping will need support from the district attorney's office. I recently got a chance to talk with Nathan Vasquez, the Multnomah County's incoming DA, about that very issue.
So there still needs to be some efforts at the state legislature if we want to see a change, or locally, we need to come up with really a system that shows and demonstrates, hey, there are shelter or housing opportunities available, and individuals are just choosing not to take those. So it's really it is a situation where we need to see some movement, either at the state legislature or whether that's locally, and creating that really what I believe is very necessary either way is a database system that can easily direct people to shelter options.
Yeah, I can drive into the airport and see immediately in the parking garages where there's open spaces. Why can't we have something like that for the homeless?
Yeah, I mean, that's a question I ask all the time because hotels do it every single day, as we know. And so it is a situation where it's going to take some leadership, and it's going to take a small amount of money. I don't think it's a massive amount to create this. I know that some of our commissioners have been very interested in doing this. I just think it needs to be pushed forward, and it's one that I believe when it gets in place, then we can start looking at, okay, A, can we really meaningfully help people get into shelter? And then B, if people are engaged in behaviors that really kind of impinge upon our other citizens, like blocking sidewalks, massive amounts of garbage, then we can start taking a little more action, I believe, in those areas.
And we are recording this before the ruling has come down, but there's a lot of assumptions that maybe it will be overturned. And I think that creates a lot of fear for some folks. But my sense is, and I want to know what you think, is in Multnomah County, we won't see any immediate change because of that state law?
Yeah, I don't expect that you'll see anything that's going to happen right away. And to be clear, I don't believe there's an appetite or an interest to be criminalizing people because they're homeless. The issue would be more, are they engaged in behaviors that are affecting other people in our community? And if we want to see those changes where we're looking at taking more assertive actions, it is going to take a change at the state legislature before any of that can happen.
Finally now, a bit of context involving what comes next for Grants Pass. They were sued by the Oregon Law Center in federal court. If the U.S. Supreme Court rules against them, legal observers tell me it's quite likely that same group will sue in state court, arguing the law there violates the state law we've been talking about. The lawsuit would be filed in Josephine County. It's a good bet that whichever way that goes at the first court level, the ruling would be appealed to the State Court of Appeals and then possibly to the Oregon Supreme Court. In the meantime, you should expect to see lots of pressure on Oregon lawmakers during the legislative session in early 2025 to change that state law. That's House Bill 3115. Many will want to get a clear definition of what reasonable means when it comes to enforcing homeless camping rules. Welcome back. We're continuing our coverage of the Supreme Court's upcoming decision on a case out of Grants Pass that will have implications on homeless policy across the country. They could overturn a ruling that currently prevents cities from fining or jailing people for camping in public areas. Right now, it's considered cruel and unusual punishment to do so in 9 western states if there are not shelter spaces available. But the High Court could decide, no, that doesn't quite meet the bar. We're expecting the court to send down their decision tomorrow or Friday. One of the biggest supporters on the side of the homeless people suing the city of Grants Pass is the National Homeless Law Center. That's a legal group based out of Washington, D.C. They've organized friend of the court briefs and demonstrations in front of the court during oral arguments. And they say if the court decides that cities can fine or jail people, it'll make homelessness worse, not better. They argue that a criminal record and fines make it harder for people to find jobs and housing. They say they'd rather see elected officials focus on solving homelessness by building more housing, not punishing people living outside.
It's sad and it's shameful to see elected officials try to deflect their failures to address their citizens' basic housing needs by blaming people experiencing homelessness. We are hearing elected officials say, the only solution we can think of is to throw people in jail. And that doesn't work. That keeps people homeless longer. Elected officials have so many tools in their toolbox to solve homelessness, whether it's funding homeless street outreach, funding safe, non-congregate shelter, funding housing that meets people's needs, funding housing that meets people's needs. But unfortunately, the only solution they're interested in is throwing people in jail, and that just won't work. We have data. We have so much data, so much evidence, so many powerful stories from people's lived experience of homelessness. We know that the solution is housing and services, not jails and fines.
There is another side to that argument, by the way. The Goldwater Institute in Arizona is preaching it. They are a conservative and libertarian think tank. They believe the Supreme Court will uphold the Grants Pass law. They argue we need to stop addressing homelessness with a rigid ideology.
The problem that we've had, particularly in the West, has been this progressive notion known as housing first, which is an ideological belief that you just need to give people housing with no strings attached and no questions asked. And of course, the problems with that, the first one is there just aren't enough houses available because zoning and other kinds of restrictions make it impossible to build housing. And the second thing is that a lot of people have bad habits, they have addiction, they have problems that make it that putting them in a shelter is not going to fix the problem without treatment. So what we need to do is replace the housing first approach with a treatment first approach. And that means going to people on a case-by-case basis to try and fix their particular problems. So as I said, the Ninth Circuit ruling being overturned is really the first step in a sane approach to this problem.
Again, that ruling is expected tomorrow or maybe Friday. We'll be watching. Keep it right here. We'll be right back after this.